Thank you, everyone, for joining us today. My name is Joshua Olshin from AuctionAdvisors. I'm here with David Fornal from Maselli Warren. Uh, David is a bankruptcy foreclosure specialist. I'm going to have him make his own introduction in a moment. But we're here to talk about, or to focus on the next 10 minutes, a little bit about the foreclosure process, how it's changed, and how it will be changed in this cycle as opposed to what people experienced in the great financial crisis when we had our last round of heavy foreclosures. So with that, David, why don't you give a quick introduction about yourself, and then I'll proceed with a couple of questions.
Yeah, thanks, Josh. Thank you to you and Warren and AuctionAdvisors for having me here today. So I'm an attorney and a shareholder at Maselli Warren. I've been in private practice for 17 years, and I am the chair of our firm's banking and creditors' rights practice. So I represent banks, financial institutions, private lenders in foreclosures, receiverships, assignments for the benefit of creditors, collection litigation, deficiency litigation, and bankruptcy proceedings. So with all that being said, you and I can go through some of the landscape.
Why don't you just maybe start off by describing a little bit about what you're seeing out there now and in the last year or so, some of what you've been experiencing and what you're expecting in the coming year.
Sure. So, I mean, for purposes of the landscape, I think when the COVID lockdowns hit at the beginning of the pandemic in second quarter of 2020, everyone was concerned and thinking that there was going to be a huge influx of foreclosures and default-related litigation. And effectively what happened was that the banks and the financial institutions were incredibly flexible in working with the borrowers in light of those circumstances. So there were a lot of workouts, there were extensions, there were deferral agreements, and there wasn't that increase. And then after those initial deferrals, then you had a lot of government stimulus that came through. So you had PPP, you had stimulus checks, you had additional federal money that was pushed into the economy and really helped a lot of the borrowers and individuals from experiencing any financial distress. Following that, with interest rates staying really low and having, in particular, the residential market exploding, there wasn't a high volume of foreclosures, at least in my practice, during the course of 2020 and 2021, and kind of just waiting for that other shoe to drop, so to speak, as the economy's been changing recently. I actually had the bulk of my practice for the past couple of years in representing banks and financial institutions was much more in line with workouts. Because borrowers were able to find their own exits. There were alternatives to foreclosures. There were alternatives to bankruptcies. With high property values and low interest rates, there's options out there, options that are better served for both the banks and the borrowers. So that's what I've seen over the past couple of years, and I think that the tides are starting to turn a little bit as the interest rates have gone up and everyone's been experiencing inflation over the past several months. Borrowers are getting a little bit more squeezed, both the consumer borrowers and the commercial borrowers in particular. So we're going to see how that plays out. A lot of my clients are projecting that come first quarter, it's going to start to see the impact of these several months that have been building with cash flow being tighter, and we'll see how that plays out.
All right. I guess during the COVID crisis, courts were closed and there was a moratorium on foreclosure. So that was particularly difficult. I know you and I worked on a few special master situations, which was a nice way to get through the foreclosure process when the courts were shut. But I assume now things are going to be open and at least legal remedies, and the foreclosure process is something that's available for banks. But maybe you can speak a little bit about how things are going to be changing or different in the next couple of years as opposed to how they were maybe during the great financial crisis. I know some of the laws have changed in New Jersey, but in general, the trend is much more expedited towards a much more expedited process, easier for the practitioner. Maybe you could speak a little bit about that.
Yeah, in particular, I mean, the bulk of my practice is in New Jersey and Eastern Pennsylvania with regard to foreclosures. But generally speaking, the big change over the past 10 to 12 years, right? If we look back a decade ago when we were in the thrust of the Great Recession, so to speak, everything was still paper filing. So in a lot of these jurisdictions, New Jersey included, you would hand deliver your papers to the court, and it could take 3 months to get your complaint back with a docket number so that you could even then go record your lis pendens and start your foreclosure process. If you wanted to move to appoint a receiver, you needed a docket number in order to file that motion. Fast forward, and you have electronic filing in almost all jurisdictions at this point, both in Eastern Pennsylvania and in New Jersey in particular. And that really increases the speed by which a bank and a creditor can get through that foreclosure process. You're going to electronically file your complaint. The same day you file your complaint, you get your docket number, you electronically file your lis pendens, or record your lis pendens at the county clerk's office, and you're off and running with service of process and seeking remedies for receiverships. If you want a rent receiver on an investment property or multifamily property, you're within your rights to pursue those immediately. So it can really increase the speed by which a foreclosure will advance in the court system. The other thing that started to happen was a decade ago when there was an influx of foreclosures. There hadn't been a high volume of foreclosures since maybe the late 80s, early 90s. So there was a gap in the case law, and everybody had to re-educate themselves with some of the same principles that existed previously as related to standing and some of those concepts. And the judges got more comfortable with those disputed issues as they were working through the system. So I anticipate that in the event that there is an increase in foreclosures come 2023 as a result of this default litigation, that there's going to be potentially a creditor-friendly bench, more so than there was during the Great Recession, at least.
And in terms of once you get the judgment, enforcing the judgment via the sheriff's office, et cetera, that's also going to be probably more expedited. And maybe you could talk a little bit about that in terms of the rules. I know I mentioned the special master, which could put a little pressure on the sheriff's office, but also there's now talk of the sheriff's office also going electronic. I don't know where we're at in terms of that process, but maybe if you could talk a little bit about, post-judgment process with the sheriff and actually implementing the foreclosure.
Yeah, so for purposes of the auction, there have been some changes. The two primary changes over the past couple of years with sheriff sales relate to, one, the adjournment process. So previously, you would get a lot of backlog in the sheriff's office because the plaintiffs could adjourn their sales in perpetuity without ever having to remove it from the sale list. And you could kind of leave it there, and then the sheriffs don't know how many cases are going to sale or not. Now the statutes have changed, and there's 5 adjournments, and it's really go forward or remove your case from the list and withdraw that. So the 5 adjournments are 2 for the borrower, 2 for the bank, and 1 by consent. Each of those adjournments is for a 30-day period. So it forces everything to have a finite period of time by which you can exercise your right to go to that auction. The other thing that changed, most importantly, as related to the special master sales in particular, which resulted in you and I working together on a number of cases in 2020 and 2021 when the sheriff's offices were effectively closed for sales, was the statute changed. Instead of scheduling a sale within 120 days, and the sheriff could schedule it, receive your package, and give you a scheduled date of 9-12 months later. But as long as they scheduled it within 120 days of receiving the package, that was sufficient. Now they have to conduct that sale within 150 days. And if they can't do that, or you don't believe that they can reasonably accomplish that, you can file a motion to appoint a special master, have someone such as AuctionAdvisors or another auction company or really anyone to be appointed as a special master to liquidate that property, hold the auction sale, and move things forward. So I don't anticipate that we're going to have the backlog and the delay at a sheriff's office like we did several years ago, because there's going to be available options.
Right. If we have one more follow-up question, so we see it often, another stumbling block to actually implementing the foreclosure is the eve of foreclosure bankruptcy filing. Maybe you could mention a little bit about how often you see that and some of the ways foreclosing parties can deal with that obstacle.
Yeah, sure. So, I mean, for purposes of, in particular in the Third Circuit, which is the bankruptcy courts in the jurisdiction where I would typically practice, there's a key distinction with regard to filing immediately before the sale or after the sale, right? If the bankruptcy by the borrower, the debtor, is filed immediately before the auction and before the gavel hits, so to speak, then the borrower has all the opportunities for purposes of a reorganization, but the creditor is going to have rights to make sure that they're adequately protected in the event that they're going to be denied relief from the automatic stay to get back to that sheriff's sale in state court. That's going to require typically payment of real estate taxes, insurance, and interest to make sure that the status quo was maintained during the bankruptcy. In the event that in the event that a bankruptcy is filed after the gavel hits, the day after the sale, for instance, in New Jersey, that would still be within the equity redemption period, but there wouldn't be a right for reorganization. The debtor would only have the right under Section 108 of the code to get the benefit of extending that equity of redemption deadline for 60 days. So they would still have 60 days where they could try to sell the property and exercise any redemption rights or find financing or whatever options might be available, but they're not going to have any rights beyond that 60-day period. So it's going to be a very short timeline if they wait too long.
Perfect. All right. Thank you very much, David. And I think
Great.